Everyone likes to have both what is agreed and what is fair. But agreements can be made hastily, unskilfully. They are always made without perfect foresight of what the future holds. Agreements can, therefore, lead to consequences that are unfair, or at least thought to be so. And in such situations, recourse can be necessary to lawyers and even to litigation. This is a talk for those litigators. How can my client get what is fair? That is to say, what is reasonable, or what accords with business common sense, or what fulfills the unitary meaning of the document in its full context, to quote some of the cases. Or alternatively, how can my client hold another to their bargain? The words of that bargain being the only admissible evidence of their intention. The toolbox available to us as litigators, advocates, lawyers is full of judicial pronouncement in both directions. Often they are uttered sequentially or said to be the same thing. And the tools can, I think, be illuminated by two modern trends. Firstly, away from what can be called the literal approach, and then back toward it. But as the trends, the emphasis have changed, the appellate courts have always maintained that the principles stay the same. So coupled with the endless variety of contexts in which commercial agreements are made, I think that this is fertile ground for the practicing lawyer. Now, a rare judicial expletive in the House of Lords can be a point of departure on the trend towards what can be called the business common sense approach. In the Antius, in 1985, the House of Lords was considering a clause that permitted termination of a contract concerning a charter party. And Lord Diblock, who gave the leading speech in that case, said this: "If detailed semantic and syntactical analysis of a word in a commercial contract is going to lead to a conclusion that flouts business common sense, it must be made to yield to business common sense." Now, in his book, Law in a Time of Crisis, published by Lord Sumption upon his retirement from the Supreme Court, he said of Lord Diblock that even by the self-confident standards of the English judiciary, he was a judge who liked to be right. He said that this dictum is cited in virtually every case where counsel contends for a result that is inconsistent with what his client appears to have agreed. And he added that for some years, Lord Diblock's pronouncement was not taken at face value. Although frequently cited, it was regarded as a mere expletive. I think the next time that I want to play down the force of an obiter dictum in a judgment, I'll try describing it as an expletive, and we'll see how that goes down. However, the Antios is still good law, and moreover, the expletive was cited with approval by Lord Hoffman in 1998 in his seminal judgment in the Investors' Compensation Scheme Limited and West Brom Building Society. The background to the case, as you can see, hopefully, was an investment scheme in the 1980s. I suspect it was sold by men with clipboards. Nowadays, similar opportunities are made available by persons with iPads. And in the early to mid-1980s, as the markets roared, homeowners were persuaded to invest the equity that they had in their homes in stock. There were probably illustrative graphs of the returns that this would yield. But the stock market crashed, house prices fell, and interest rates on mortgages skyrocketed. Disaster struck. And that disaster was so widespread and serious that the government, under the guise of the FSA, created the ICS Limited. And the idea was that the ICS would compensate the consumer directly, and that the consumer would assign their rights in any claim against the broker to the ICS, and that the ICS would then take over any litigation on their behalf. However, lawyers got involved. Someone hit upon the idea that they could do better than that, and that there were residual claims that the ICS were not pursuing. And so they went to court and tried to persuade, in this case, the House of Lords, that the consumer, having been compensated once by the ICS, was entitled to have another go with them. And Lord Hoffman, in his judgment, set out the structured 5-stage approach, which is set out on the slide. And you may be glad to know, I'm just going to pick out a few words which I think emphasize the drift of the test. 1, interpretation is the ascertainment of the meaning which the document would convey. 2, the matrix of fact is an understated description for the background circumstances, which include absolutely anything which would have affected the way the language should be understood. 3, parole evidence, evidence of previous negotiation, is inadmissible. In this respect only, legal interpretation differs from the way we would interpret utterances in ordinary. 4, the meaning of a word is not a matter of dictionaries and grammars. The meaning of the document is what the parties using those words meant. And 5, the law does not require judges to attribute to the parties an intention which they plainly could not have had. Lord Sumption, again, who deprecates the term literalist, but I suspect is as close to an example of it as might be found, credited the judgment with a shift in the culture of interpretation in the commercial court. As to the suggestion that had been made in some quarters that there had been unintended consequences of misunderstood remarks, Lord Sumption said, Lord Hoffman was not a judge to decide cases by accident. I think it is exactly what he intended. However, the criticism of this approach made by that author is that it reduced the words used by the parties to little more than a rebuttable presumption. In 2004, things were taken on a little further. In serious international and FAI general insurance, Lord Steyn said, giving the leading judgment, the tendency should therefore generally be against literalism. And he borrowed from the writings of William Paley on moral philosophy, which he stated were influential on the development of 19th century contract law. The tyrant Timures promised the garrison of Sebastia that no blood would be shed. They surrendered. He shed no blood. He buried them all alive. This is literalism. If possible, it should be resisted in the interpretive process. Setting aside the more modern jurisprudence of human rights law, the laws of war, and humanitarian law, who would say that Timures actually breached his agreement with the garrison? Would anybody like to defend him? Say they shouldn't have been so stupid, come to me for advice the next time. Now, as an aside, it may be said that in Paley's writing, the moral objection to the approach taken by Timures at Sebastia was a lack of honesty. He had tricked the garrison into believing his intention was different to that which it actually was. And it might be said to be a better moral argument in favour of doctrines of, for example, misrepresentation than the interpretation of contracts literally. But the high tide had not yet been reached, and it is often said that that time arrived in 2011 in the Supreme Court judgment in Rainy Sky and Cookman Bank. The various appellants in that case, of whom Rainy Sky were one, and I dare say they had the best name, which is why they were the lead appellant, were purchasers of shipping vessels from a particular supplier, and the price per vessel was $33.3 million, payable in 5 installments of $6.6 million, the last installment on receipt of the vessel. The contract provided for circumstances in which a refund of the installments would apply, and the buyer also sensibly required from the seller a bond issued by a bank guaranteeing that refund. And just beginning to look a little more closely at some of these principles in action, this is what the bond said. Materially, it began by saying, pursuant to the terms of the contract, you're entitled upon your rejection of the vessel, in accordance with the terms of the contract, your termination, cancellation, or rescission of the contractor, to repayment. And then at paragraph 3, we hereby, as primary obliger, irrevocably and unconditionally undertake to pay to you your successors and assigns on your first written demand all such sums due to you under the contract. So, problem, the builder went bust under Korean law. And under the contract, the buyer was entitled to a refund. However, there was a problem. Under paragraph 2, the liability of the bank, they said, was limited to termination, cancellation, rescission of the contract. And none of those events under the governing contract had occurred. This was just a refund under a separate provision. The unanimous judgment of the court was given by Lord Clark. And he said that looking at the bond, it was capable of being construed either way. said, well, the buyers don't really have a very good reason why those words in paragraph 2 should be there, unless it's to limit the liability that they have under paragraph 3. But on the other hand, the words of paragraph 3 are very clear, and it's not particularly unusual to have some verbosity, some unnecessary words elsewhere in agreement. And of the two competing explanations, it was obvious to the court which accorded better with commercial common sense, and therefore should be given effect, prevail, and entitle the buyers to their refund. And Lord Clark said this: the language used by the parties will often have more than one potential meaning, and I would accept the submission made on behalf of the appellants that the exercise of construction is essentially one unitary exercise in which the court must consider the language used and ascertain what a reasonable person, that is, someone with the background knowledge, would think that they intended. So that was 2011 in the Supreme Court. And by 2015, the chairs in the Supreme Court had changed. The president of the Supreme Court was Lord Neuberger, who had not been a party to Rainy Sky. He presided over a constitution of the court that contained Lord Sumption. And they had a case called Arnold and Britton, which was all about holiday chalets on the Gower Peninsula. This was a case about service charges payable on a 99-year lease. And these were £90 per annum in the 1970s when the leases were agreed. And they were expressed to increase by a rate of 10% every year thereafter. I've got a nice little caption about the power of compound interest. And this is the position that by 2072, the service charge on a single chalet in the holiday park would be just over £550,000 per annum. Rainy Sky and ICS and West Brom were cited and explicitly followed by the Supreme Court in Arnold and Britton. But the court went on to make 7 further observations or qualifications, and there are just 3 of them that I think bear emphasis in the limited time that are available today. 1, commercial common sense should not be used to undervalue the words used by the parties. 2, commercial common sense must not be used retroactively. And for all that this was an extremely literal interpretation of a contract in the Supreme Court, there was considerable discussion of the RPI since the 1970s, and considerable discussion of the notion that this 10% compounding might not have seemed as outlandish at that time as it does now. And thirdly, the court should not rewrite a bargain that was merely imprudent on one side. So in this case, the court upheld the service charge. They declined to imply the words up to into the contract. And the judgment and the consequences of the judgment were later described by Lord Sumption extrajudicially again as, quote, harsh. Things were taken along a little further in Wood and Capita Insurance, 2017. Lord Sumption again on the panel, the leading judgment on this occasion being given by Lord Hodge. Now, Mr. Wood, he was the majority shareholder in a business that was involved in brokering insurance sales. And what happened was people would click on one of the online comparators, they'd be given a number to ring, they'd be referred to someone who worked essentially for Mr. Wood, and then they would sell him a policy over the phone. And he, happily for him, I suppose, was able to sell that business to Capita Insurance Services Limited for £7.6 million. Unfortunately for Capita, after they bought the business, they discovered that there had been widespread mis-selling by the representatives of the brokerage, and they'd been misrepresenting to customers what their risk profile was in order to sell them more expensive policies and no doubt garner better commissions. Capita was obliged to and did self-refer to the FSA, and they were facing a total loss on the mis-selling of about £2 million. Now, fortunately, also it seemed, there was an indemnity, and this is what it said. It is a bit wordy. It was blamed as a piece of drafting in the Supreme Court for any of the ills that could be visited upon either party. The sellers undertake to pay to the buyer an amount equal to the amount which would be required to indemnify the buyer and each member of the buyer's group against all actions, proceedings, losses, claims, damages, costs, charges, expenses, and liabilities suffered or incurred, and all fines, compensation, or remedial action or payments imposed on or required to be made by the company. And there was, again, a problem that was not perhaps visible on first blush. And it's these words, about 2/3 of the way down, made by the company following and arising out of claims or complaints registered with the FSA. So Mr. Wood, the appellant in the Supreme Court, went to the Supreme Court and made the argument that because no one had complained, no consumer had complained to the FSA or brought a claim, the indemnity that he gave the buyer against mis-selling was ineffective. Now that has to be one of the most unattractive arguments that you could possibly present. I would anticipate that if you are selling a company that has been mis-selling, it is not something that you are likely to be able to disclose. And so in that sense, it is likely to be something of a trick a la Tabourez the Tyrant. And the Supreme Court prefaced its analysis of this by citing ISC and West Brom, citing the judgment of Lord Cork as an elegant summary of the existing principles, and then went on to look very carefully at the contracts and say, yes, that's absolutely right. It's a badly drafted indemnity. This SPA was a complex, professionally drafted document. There was a lot of money on the table, and you've only got yourselves, or more likely your solicitors, to blame. Again, a very literal approach, but just looking at that indemnity again, indemnify against all actions, proceedings, losses, claims, damages, costs, charges, expenses and liabilities. So that, you might think, is a conjunctive use of the word and between expenses and liabilities. suffered or incurred, comma, and you might think that that comma after the word incurred signals that it's a disjunctive use of the word and if you were of that view, it would be possible to conclude as a matter of strict literal interpretation that the first part of the indemnity was operative to give indemnity against all mis-selling losses. The difficulty that the Supreme Court saw with that is that it meant that some of the words that followed were otiose. If we reflect for a moment that, as perhaps in Rainy Sky, this is a clause which is at least capable of intelligibly bearing two competing constructions, then it would seem to be obvious which of those constructions business common sense or the factual matrix would favour, and that the clause would be interpreted as giving a full indemnity. If the parties had been asked, which they could not be at the time that they signed this contract, if they believed that a full indemnity was being provided, I think there can be a very high degree of confidence that both of them would have said yes. So is this the final word on contractual interpretation in the Supreme Court? I would venture to suggest no. The Supreme Court in Arnold was adamant that the applicable legal principles had never changed, and they said in particular this: the recent history of the common law of contractual interpretation is one of continuity rather than change. One of the attractions of English law as a legal system of choice in commercial matters is its stability and continuity. I think that that is an important tell into the motivations of the Supreme Court, because the Commercial Court in London is big business. And it is also quite obviously, in my opinion, not reflective of the various statements that have been made over a period of about 20 years. Moreover, if it was right that in Wood no complicated point of law had been decided, then we had the Supreme Court deciding a case with no point of law of general public importance and simply construing a provision in an individual SPA. That cannot be correct. Moreover, Lord Sumption, who has indicated joined the judgment in Wood, later wrote in a footnote to his book, in the lecture which had preceded the book, I deliberately avoided saying that Rainy Sky was wrongly decided. I felt inhibited because I was still a member of the court, because some of my colleagues had been party to that decision, and because I might have to decide the question judicially in a future case. Today, none of those considerations apply. In my view, Rainy Sky was wrong. Well, that poses the question, why? And so, to my mind, this is indeed fertile ground for the advocate. Different judgments of the same court, claiming to speak with a single voice, simultaneously extolling pragmatism and literalism. Generally, I suspect that our clients will believe that what was agreed is fair, or that what is fair is what was agreed, even if that is not the case. So as Captain Jean-Luc Picard would say, make it so. And that is the conclusion.